fact, some of the complaints about the courts in the 15th century sound very familiar nowadays. So the common law courts by the 15th century were said to have become rather slow, rather expensive, and in particular they'd become very technical. As I said, these are problems that people talk about today. It was also true that juries were being used in both criminal and civil cases, and there was a concern that there was scope for juries to be either intimidated by defendants or friends of the defendant, or indeed that juries could be bribed. So there was a concern about the use of juries in civil and criminal cases, but there was also a concern that the system of writs had become very rigid. A writ was essentially permission granted by the king for a party with a complaint to sue another party, one of the king's subjects, in the king's courts. So the writ is a permission that a person needs to bring their grievance to the king or to one of the king's justices to have that case decided. So despite the development of common law courts, the king himself continued to be a source of English law. Even after the law courts had developed, people still sometimes petitioned the king for justice. This is known as petitioning the king. The king was regarded as the fountainhead of all justice, from whom redress could be sought if a subject felt that he couldn't get justice in the ordinary courts. People petitioned the king to redress their grievances, and that meant that they would plead directly with him to hear their complaints and provide them with a remedy. The procedure for petitioning the king at this time was to present him with a petition or bill asking him to do justice in respect of some complaint. And this was going on at the same time as the common law courts were dealing with cases. So people would sometimes throw themselves on the king's mercy or the king's conscience when they felt for some reason that they weren't able to get a remedy through the ordinary system, through the common law courts, common law justices. They would petition the king directly and appeal to the king's conscience for some kind of remedy. Now, for a time, the king or the king in council with his advisors dealt with these petitions himself. But gradually, the number of petitions coming directly to the king began to grow. And the king developed the practice of passing these petitions on to his chancellor. The chancellor was known as the keeper of the king's conscience. The chancellor was usually a clergyman, bishop, somebody who would be learned in civil and canon law. So the chancellor, trusted advisor, a cleric who knew about the law. The king, over time, through his chancellor, eventually set up a special court known as the Court of Chancery. And the idea of the Court of Chancery was to deal with these petitions that were going not to the common law courts but coming directly to the king and appealing to the king to decide the case on the basis of his conscience. The chancellor supervised the chancery, and clerks in the chancery would issue writs, that's permissions, and other legal documents. The chancellor dealt with these petitions in a different way from the common law justices. Rather than looking at common law precedents, what the chancellor would do was to deal with petitions on the basis of what was morally right.